I'm here sui juris in propria persona. I reserve all rights. I, Jonathan - Troy Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress.
Today we're reviewing an intense courtroom moment that many of you sent in. It comes out of Washington and features a familiar figure, Jonathan Schuster. If that name sounds familiar, it's because we've talked about him before. He maintains that being from American Samoa somehow makes him a different class of national who isn't bound by U.S. law. Whatever theory he prefers, the legal system does not see it that way. Statutes still apply. We already covered his arraignment. Now there are 2 additional hearings to go through, and the exchanges only grow more chaotic as they
interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying, is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is commercial court.
It's not commercial court.
Now you're saying that my social security number is attached to these charges. And so, which means this is assessed a case trust action, which you are a real party in interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating...
At one point, he references a supposed trust arrangement. The immediate reaction from the commentary is simple. Can he actually define what he's talking about? That challenge alone highlights the issue. In earlier footage, he confidently misused legal terms. And here we see the same pattern again. Certainty without clarity. Unfortunately for him, the judge he's facing isn't interested in slogans or memorized lines. Each claim is addressed and taken apart as soon as it appears.
If you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm beneficiary. I am here sui juris in propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr. Schuster?
Please do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or cysticate trust action. And so I'm here sui juris in propria persona. You know what that means. And so we can prove...
I don't know what it means because it's nonsense, but nonetheless...
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those three?
Nobody's going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you I'm here sui juris in propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're going to have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Okay. Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's
can't.
no need to
We
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
It's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
arguing.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court.
There's a sarcastic aside from the narrator as Schuster ramps up the theatrics, poking fun at how dramatic the display has become. Meanwhile, the judge stays calm and keeps everything anchored in ordinary legal reality, refusing to be pulled into the performance.
Friend, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you don't come back on July 1st,
Are you threatening me now?
I'm telling you there's going to be a bench warrant issued if you don't show up.
You're
So
threatening me now.
I'm giving you the choice of showing up or a bench
I'm
warrant
giving you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July. I am telling you your
I'm telling
options.
you this matter needs to be dismissed with prejudice because you cannot prove jurisdiction. This is a
Signature here.
trust action.
Signature here,
You're trying to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud.
So-
I'm speaking with that.
You're done.
No,
you're done.
you can't tell me I'm done.
I can.
No, you don't have power to do that.
Your court case is over.
You don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now.
I'm
Even more.
Another response from the commentary focuses on a basic point. Once someone chooses to operate a vehicle on public infrastructure, they are participating in a system governed by rules created by the relevant authorities. That principle isn't optional, and there isn't a hidden exception waiting to be unlocked through wordplay. If a person truly wants to avoid that arrangement, the alternative would be avoiding those public resources.
You can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to. I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster, I
reserve all rights.
did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Counsel to me
Well,
without my permission. He has no permission to be my counsel. I'm here sui juris, appropriate persona. I, Jonathan Tyson, Troy Faifaleo Somalia Toa Colin Schuster, am here under fraud, menace, and duress. I've made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
well, right
Are you
now,
able to answer them?
I am not here to be interrogated by you. You are under the jurisdiction of this.
Going on here.
I think you understand and you choose not to
I do
take
not
in the information.
understand
Okay, well,
what's going on
Mr. Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right, in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would.
represent myself.
Well, you would. Either you
I
have
don't.
counsel or you are acting pro
Represent
se.
myself. And so, like I have told you, I'm here sui juris appropriate persona. I challenge the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction, or is this an admiralty maritime jurisdiction?
Either. So,
Right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record,
If you would like,
step up so you can hear me better, and I will
none of
speak
it's being
louder.
preserved.
I will speak louder.
Then comes a reminder that makes his position even harder to maintain. He previously accepted a deferred prosecution agreement. By doing so, he acknowledged the court's power and promised to comply with the law. Trying to deny that authority now clashes directly with the commitment he already made.
So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. The fact that I think it's not that you don't understand, I think it's you choose not to understand, and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect that is causing you to not be able to
challenge my competency. Because I have challenged the jurisdiction of this court, and you have not proved the jurisdiction.
In Social Security or contract
you
or
have to
maritime.
prove jurisdiction before we can move any further.
So that's just not how it works in this court, and
No,
I don't think you have the legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Miss Jennifer. Can you prove
I'm Judge Grant, so I'm going to
Jennifer,
have you.
Can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training, so that I think is
that does
clear.
not matter.
Well,
if I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must.
The commentary points out another contradiction. If his stated priority is taking care of his family, repeatedly ignoring legal requirements, like licensing, creates the very risks he says he wants to avoid. Actions and goals aren't lining up.
the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So, Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Oh, absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We
that.
have a speedy trial at
It is
August
the burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table, a waiver of counsel, so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you.
We cannot move until jurisdiction has been proven.
Yeah, there should be a.
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
So, Mr. Schuster, did the court say that was end of August, or?
It was August 9th.
Yet he continues, speaking with total confidence, while the substance of the argument drifts further away from anything the courtroom recognizes as valid. Determination, by itself, doesn't transform an idea into something persuasive.
More than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
Does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you. You are subject to another court, and they could very well
get in trouble. And you have to prove jurisdiction. You haven't done that, and you failed
obviously
to do that.
You believe that courts do have jurisdiction over you.
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is, and this is just a waste of time at this point. So whatever you need to do to prove jurisdiction, but I know you can. So if you want to waste more of everybody's time, go ahead, because obviously I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity. And that's ridiculous for what's going on here. That's absolutely ridiculous. And so
I don't think
this matter
anyone
needs
is
to be
being
dismissed with
put
prejudice.
into captivity.
And whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead. But obviously you can't prove jurisdiction. So
I'm looking for the more detailed counsel waiver.
It's absolutely ridiculous.
I don't know that he's done that yet.
No, he hasn't. I have a streamlined version, but I want him the formal,
The detailed one.
the detailed one.
We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power.
As this unfolds, it becomes clear the matter isn't ending with him walking out. The judge is preparing to remind him that the proceedings are still underway and that leaving isn't an option. When Schuster suggests he should be able to go, the answer is immediate. Not yet.
Present, and you want to act as your own attorney.
I've said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel.
I'm here of my own right in my proper person. You know what that means.
So there's the form.
I've never signed my power of attorney away to anybody, especially this.
You need to be respectful. You are really out of line, Mr. Schuster.
I didn't say anything disrespectful.
You are being very disrespectful.
You were being very disrespectful, actually, because you're violating my rights.
So I'm going to set this on for the August term. I'm going to have you take this form.
Wasting my time.
Mr. Schuster.
When you're taking away my ability to provide and work.
Have a seat there so you can fill out this form.
What's that?
You can have a seat there so you can fill out the form.
You're dismissed. Do you need anything else?
Yes, I do. I need you to take that form. So we're going to have to go through that because this case is going to be going to trial. It's going to be set on the August term. That would be August 6th, and that will be at 9 a.m.
Advice follows that he would be wise to use the attorney available to him. Because of the deferred prosecution status, a new conviction could have wider consequences than he seems to understand. Penalties from different matters might be added together, turning a bad situation into something far more serious.
You cannot move any further until you prove jurisdiction.
And the readiness hearing will be July 31st, and that will be at 2 p.m. And that hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you can practice law on the bench.
So, Mr. Schuster, if you choose not to come to your court hearings, a warrant will issue for your arrest.
You're threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep. These are jailable offenses, but for this
Absolutely
hearing,
ridiculous, Ms.
we need
Jennifer.
your presence to appear.
Absolutely ridiculous.
All right, so let's get a court date form for him.
Absolutely ridiculous.
That's the date for the interview.
Could back there?
We can set a pre-trial. Let's do it on the 22nd.
Prosecuting attorney also needs to provide any contracts that I've entered into internationally,
Here's your court date. Could you please sign for that?
especially if this is an admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So,
Mr. Schuster, you are in a criminal court, and there are court rules. If you wish to
this is a criminal matter, you said?
Mr. Schuster, if you wish to have discovery, then
Interview 10. That's where we'll pause for now. There are still several dates ahead on the calendar, and I'll continue tracking each development and bringing updates as they happen. If you found this overview,
send you the discovery, all of the evidence that we have against you at trial. Did you understand that?
I don't understand what's going on with this.
So
This is
here's my
Kangaroo
suggestion,
court.
Mr. Schuster.
Kangaroo court. And so since you guys are going to waste everybody's time even more, goodbye.
Mr. Schuster, you need to sign for your court dates. I'm giving them to you orally.
Have a good day. Aloha.
If you don't
helpful, tap like. If it wasn't your thing, you can tap dislike. Either way, share your thoughts below and subscribe with notifications so you're ready for the next chapter, because this case is still unfolding.